Babri Masjid was destroyed by Hindu Taliban, Litigant tells Supreme Court senior advocate Rajiv Dhawan, appearing for the legal heirs of original litigant M. Sadiq, also questioned the locus of the Shia Central Waqf board in the case. New Delhi, the Babri Masjid was destroyed by the Hindu Taliban, just like the demolition of the Buddhist statue by the Taliban at Balmain in Afghanistan. A litigant in the Ayodhya Temple Mosque land dispute case told the Supreme Court on Friday. No law or the Constitution allows destruction of religious structures of any faith, senior advocate Rajiv Dhawan, appearing for the legal heirs of M. Sadiq, the original litigant who died, told the bench of Chief Justice Deepak Misra and Justices Ashok Bhushan and S. Abdul Nazir. Dhawan also questioned the locus of the Shia Central Waqf board in the case. His comments came after the Shia board told the bench that it was willing to donate one-third of the disputed land, which the Allahabad High Court had given to the Muslims, to the Hindu group for peace, harmony, unity and integrity in this great country. The counsel for the Shia Central Waqf board said they were the claimants of the Muslim share of land at the disputed Ayodhya site, as the Babri Masjid was built by Mir Baqi, a Shia Muslim. It is a fundamental issue. The Shia Central Waqf board has decided that for the unity, integrity, peace and harmony of the country, we want to donate the one-third part of land to the Hindu groups, the lawyer said. Dhawan, who initially said he would not respond to innuendos, later countered the Shia board's submissions and said it was way back in 1946 that the Babri Masjid was held to be a Sunni mosque. You cannot argue that this demolition of mosque was by some miscreants, he said, adding, what had happened in 1992? The Balmain statue was destroyed by the Taliban and this mosque was destroyed by Hindu Taliban. It cannot be done. It should not have been done. No one can do this. He argued that those who destroyed the mosque should be barred from making any claim since no one has the right to destroy a mosque or any other religious structures. The simple argument is that the fact that a mosque is destroyed does not conclude the argument of right to prayer, he said. Dhawan said the Shia board's argument that it wanted to donate a share of the land to the Hindu group was like indulging in a non-existent act of charity. He also questioned the intervention of an additional Solicitor General (ASG), who was appearing for Uttar Pradesh government in the matter and said that arguments by the law officer were uncalled for. On July 6, the UP government had told the apex court that some Muslim groups were trying to delay the hearing in the long-pending land dispute case by seeking reconsideration of an observation in the 1994 verdict in M. Ismail Faraqui case that a mosque was not integral to Islam. During the arguments on Friday, Dhawan said there was no delay on their part in the matter and the UP government was supposed to remain neutral in the dispute. He said that after the Faraqui case verdict, no occasion arose to ask for setting aside or modification of this judgment, and, as per this verdict, the center was to act as statutory receiver of the disputed land. That neutrality of UP has been broken by the ASG. The ASG is the additional Solicitor General of the Government of India. Union of India has to act as statutory receiver. It does not lie in the mouth of an officer of the Government of India to say that a matter is delayed and there is no bona fide, he said, adding, it is simply impermissible and a breach of faith of this court. He said the issue of Faraqui's verdict was raised by the opposite parties in the suits before the High Court. Dhawan also countered the arguments advanced by the Hindu group about pilgrimage, and said as per their submissions, the Muslims do not have the right under Article 25 freedom of conscience and free profession, practice and propagation of religion. He said if arguments by Hindu group were to be accepted, then Christians might be asked to go directly to the Pope for prayers and Sikhs could be asked to go only to the Golden Temple at Amritsar. At the outset, the Shia Central Waqf board said the matter should not be referred to a larger bench for any reconsideration of the observations made in Faraqui's verdict. The Muslim groups have argued before the bench that the sweeping observation of the apex court in the verdict needed to be reconsidered by a 5-judge bench, as it had and will have a bearing on Babri Masjid Round Temple Land dispute case. Davin had earlier termed the Allahabad High Court's verdict of dividing the 2.77-acre disputed Ayodhya land equally among the Sunni Waqf board, the Nirmohi-Akara and Ramlala as Panchayat decision. Earlier, Hindu groups had opposed the plea of their Muslim counterparts that the 1994 verdict holding that a mosque was not integral to the prayers offered by the followers of Islam be referred to a larger bench. A 3-judge bench of the Allahabad High Court, in a 2-to-1 majority ruling, had in 2010 ordered that the land be partitioned equally among 3 parties, the Sunni Waqf board, the Nirmohi-Akara and Ramlala.